General defenses under Law of Torts. Introduction. Whenever a case is brought against the defendant for the commission of a tort and all the essential elements of that wrong are present, the defendant would be held liable for the same. Even in such cases, the defendant can avoid his liability by taking the plea of the defenses available under the Law of Torts. Some defenses are particularly relating to some offenses. In the case of defamation, the defenses available are fair comment, privileges and justification, etc. Let's see what are these defenses available to a person under the Law of Tort and how can it be pleaded along with some of the important cases. Meaning of general defenses. When a plaintiff brings an action against the defendant for a tort committed by him, he will be held liable for it, if there exists all the essential ingredients which are required for that wrong. But there are some defenses available to him using which he can absolve himself from the liability arising out of the wrong committed. These are known as general defenses in the Law of Tort. The defenses available are given as follows. Valenti non fit injuria, or the defense of consent. The wrongdoer is the plaintiff. Inevitable accident. Act of God. Private defense. Mistake. Necessity. Statutory authority. Valenti non fit injuria. In case a plaintiff voluntarily suffers some harm, he has no remedy for that under the Law of Tort and he is not allowed to complain about the same. The reason behind this defense is that no one can enforce a right that he has voluntarily abandoned or waived. Consent to suffer harm can be express or implied. Some examples of the defense are: when you yourself call somebody to your house, you cannot sue your guests for trespass. If you have agreed to a surgical operation, then you cannot sue the surgeon for it, and if you agree to the publication of something you were aware of, then you cannot sue him for defamation. A player in the games is deemed to be ready to suffer any harm in the course of the game. A spectator in the game of cricket will not be allowed to claim compensation for any damages suffered. For the defense to be available, the act should not go beyond the limit of what has been consented. In Halve. Brooklands Auto Racing Club, 1. The plaintiff was a spectator of a car racing event and the track on which the race was going on belonged to the defendant. During the race, two cars collided and out of which one was thrown among the people who were watching the race. The plaintiff was injured. The court held that the plaintiff knowingly undertook the risk of watching the race. It is a type of injury which could be foreseen by anyone watching the event. The defendant was not liable in this case. In Pudmofty v. Aduganika, 2, the driver of the Jeep took the Jeep to fill petrol in it. Two strangers took a lift in the Jeep. The Jeep got toppled due to some problem in the right wheel. The two strangers who took lift were thrown out of the Jeep and they suffered some injuries leading to the death of one person. The conclusions which came out of this case are: the master of the driver could not be made liable as it was a case of a sheer accident and the strangers had voluntarily got into the vehicle. The principle of valenti non fit injuria was applicable here. Consent must be free. For this defense to be available, it is important to show that the consent of the plaintiff was freely given. If the consent was obtained under any compulsion or by fraud, then it is not a good defense. The consent must be given for an act done by the defendant. For example, if you invite someone to your house for dinner and he enters your bedroom without permission, then he will be liable for trespass. In the case of Lakshmi Rajan v. Mailer Hospital, 6, a 40-year-old married woman noticed a lump in her breast, but this pain does not affect her uterus. After the operation, she saw that her uterus has been removed without any justification. The hospital authorities were liable for this act. The patient's consent was taken for the operation, not for removing the uterus. If a person is not in a condition to give consent, then her guardian's consent is sufficient. Consent obtained by fraud. Consent obtained by fraud is not real consent and does not serve as a good defense. In Hegarty v. Shine, 7, it was held that mere concealment of facts is not considered to be a fraud so as to vitiate consent. Here, the plaintiff's paramour had infected her with some venereal disease and she brought an action for assault against him. The action failed on the grounds that mere disclosure of facts does not amount to fraud based on the principle ex turpi causa non order actio, i.e., no action arises from an immoral cause. In some of the criminal cases, mere submission does not imply consent if the same has been taken by fraud which induced mistake in the victim's mind so as to the real nature of the act. If the mistake induced by fraud does not make any false impression regarding the real nature of the act, then it cannot be considered as an element vitiating consent. In R. v. Williams, a music teacher was held guilty of raping a 16-year-old girl under the pretense that the same was done to improve her throat and enhancing her voice. Here, the girl misunderstood the very nature of the act done with her and she consented to the act considering it a surgical operation to improve her voice. In R. v. Clarence, the husband was not liable for an offense when intercourse with her wife infected her with a venereal disease. The husband, in this case, failed to inform her wife about the same. Here, the wife was fully aware of the nature of that particular act and it is just the consequences she was unaware of. Consent obtained under compulsion. There is no consent when someone consents to an act without free will or under some compulsion. It is also applicable in the cases where the person giving consent does not have full freedom to decide. This situation generally arises in a master-servant relationship where the servant is compelled to do everything that his master asks him to do. Thus, there is no applicability of this maxim valenti non fit injuria, when a servant is compelled to do some work without his own will. But, if he himself does something without any compulsion, then he can be met with this defense of consent. Mere knowledge does not imply assent. For the applicability of this maxim, the following essentials need to be present. The plaintiff knew about the presence of risk. He had knowledge about the same and knowingly agreed to suffer harm. In the case of Bowater v. Rowley Regis Corporation, a cart driver was asked to drive a horse which to the knowledge of both was liable to bolt. The driver was not ready to take that horse out, but he did it just because his master asked to do so. The horse then bolted and the plaintiff suffered injuries. Here, the plaintiff was entitled to recover negligence of the defendant. In order to avail this defense, it is necessary that the defendant should not be negligent. If the plaintiff consents to some risk, then it is presumed that the defendant will not be liable. For example, when someone consents to a surgical operation and the same becomes unsuccessful, then the plaintiff has no right to file a suit, but if the same becomes unsuccessful due to the surgeon's negligence, then in such cases he will be entitled to claim compensation. In Slater v. Claycross Company Limited, the plaintiff suffered injuries due to the negligent behavior of the defendant's servant while she was walking along a tunnel which was owned by the defendants. The company knew that the tunnel is used by the public and had instructed its drivers to give horns and drive slowly whenever they enter a tunnel. But the driver failed to do so. It was held that the defendants are liable for the accident. Plaintiff the wrongdoer. There is a maxim ex turpi causa non order actio which says that from an immoral cause, no action arises. If the basis of the action by the plaintiff is an unlawful contract, then he will not succeed in his actions and he cannot recover damages. If a defendant asserts that the claimant himself is the wrongdoer and is not entitled to the damages, then it does not mean that the court will declare him free from the liability, but he will not be liable under this head. In the case of Bird v. Holbrook, the plaintiff was entitled to recover damages suffered by him due to the spring guns set by him in his garden without any notice for the same. Valenti non fit injuria and contributory negligence. Valenti non fit injuria is a complete defense, but the defense of contributory negligence came after the passing of the Law Reform, Contributory Negligence, Act, 1945. In contributory negligence, the defendant's liability is based on the proportion of fault in the matter. In the defense of contributory negligence, both are liable, the defendant and the plaintiff, which is not the case with valenti non fit injuria. In valenti non fit injuria, the plaintiff knows the nature and extent of danger which he encounters, and in case of contributory negligence on the part of the plaintiff, he did not know about any danger. Act of God. Act of God serves as a good defense under the law of torts. It is also recognized as a valid defense in the rule of strict liability in the case of Rylands v. Fletcher. The defense of act of God and inevitable accident might look the same, but they are different. Act of God is a kind of inevitable accident in which the natural forces play their role and causes damage. For example, heavy rainfall, storms, tides, etc. Essentials required for this defense are: natural forces working should be there. There must be an extraordinary occurrence, and not the one which could be anticipated and guarded against reasonably. Inevitable accident. Accident means an unexpected injury, and if the same accident could not have been stopped or avoided in spite of taking all due care and precautions on the part of the defendant, then we call it an inevitable accident. It serves as a good defense as the defendant could show that the injury could not be stopped even after taking all the precautions and there was no intent to harm the plaintiff. In Stanley v. Powell, the defendant and the plaintiff went to a pheasant shooting. The defendant fired at a pheasant, but the bullet, after getting reflected by an oak tree, hit the plaintiff and he suffered serious injuries. The incident was considered an inevitable accident and the defendant was not liable in this case. Conclusion. We divided the general defenses under Law of Torts into two parts. This is part 1.